But today I'm very excited to really be back in Geneva and be back in person as well. Not only to welcome new participants, but also to welcome a very wonderful group of people who are experts in their field. And that is the field of climate change, climate justice, of which today's lecture is. But I will not necessarily tell you who those people are. That's not necessarily my job. I'll leave that to others. But for now, I would like to welcome Dr. Domenico Zappoli to the stage to offer his words of welcome on behalf of the Geneva Academy. Domenico, please.
Good afternoon, everyone. Excellencies, honorable judges, colleagues, and above all, dear students. It's a great pleasure and privilege to welcome you all on behalf of the Geneva Academy of International Humanitarian Law and Human Rights to this third annual Nelson Mandela Human Rights Lecture presented by the Center for Human Rights of the University of Pretoria, the American University Washington College of Law, the Commonwealth Secretariat, and the Office of the UN High Commissioner for Human Rights in collaboration with the Geneva Academy. My name is Domenico Zappoli. I'm a research fellow and project coordinator at the Geneva Human Rights Platform at the Academy. And in line with today's important occasion, the aim of the Geneva Human Rights Platform is to provide a dynamic forum in Geneva for all stakeholders in the field of human rights, experts, practitioners, diplomats, and civil society to discuss and debate topical issues and challenges relying on academic research and findings. The theme for today's lecture is climate justice, an indispensable concept, framework, and guide for addressing the existential threat posed by the climate crisis. We are particularly delighted to be part of the organizers of this lecture and that this multi-stakeholder debate is taking place in the context of International Geneva, a place that saw the lobbying of hundreds of NGOs for over a decade towards the creation of the mandate of the Special Rapporteur on the Promotion and Protection of Human Rights in the context of climate change, established by the Human Rights Council at its historical 48th session in October 2021. Today is, of course, not a day like any other, as it is, as we celebrate the birthday of one of the world's great heroes, Nelson Mandela. And in recognition of the former South African president's contribution to the culture of peace and freedom, the UN General Assembly in 2009 declared July the 18th to be Nelson Mandela International Day. As such, today represents an important opportunity to reflect back on Nelson Mandela's courageous life in order to draw inspiration from one of the world's moral bulwarks in the face of oppression, racism, injustice, and inequality. And while climate change was perhaps not the issue that defined Mandela's long walk to freedom, his philosophy and life path demonstrate a clear overlap with the principles and commitments of the climate justice movement. Mandela's reliance on the African spiritual ethic of Ubuntu is a glaring example of such overlap. The concept of Ubuntu, which derives from the Xhosa Zulu culture in which Mandela was born, can be succinctly translated to mean a person is a person through other persons, or I am because we are. And from his autobiography, we learn that Mandela's long walk to freedom included steps to solve the climate crisis through the belief that all people should live in a fully dignified life with clean air to breathe and clean water to drink, and where poor countries are not left with the repercussions of rich nations' polluting ways. During his 27-year imprisonment, he insisted to have a garden installed on the roof of his prison, where he and his fellow inmates could grow vegetables for their meals. In his autobiography, he writes, "To plant a seed, watch it grow, to tend it, and then to harvest it, offered a simple but enduring satisfaction. The sense of being the custodian of this small patch of earth offered a small taste of freedom." After he left office in 1999, Nelson Mandela founded a group called the Elders. This prestigious cross-cultural group of leaders, which today includes former High Commissioner for Human Rights Mary Robinson, as well as former High Commissioner of Human Rights Zeid Ra'ad Al Hussein, among others, seeks to create human rights-oriented solutions to complex global problems. And one of the group's top priorities since its inception is that of tackling climate change, with a specific eye on those most affected by its impacts. Yet another example of Mandela's legacy towards tackling the climate crisis through justice. Today is not a day like any other, also because this third Nelson Mandela annual lecture is the first in-person annual lecture since the untimely passing of another giant that South Africa has gifted us all with. Indeed a giant, or as the executive director of Amnesty International South Africa eloquently described him as, a baobab on the landscape of international human rights law, Professor Christoph Heinz. Our beloved and much missed professor of human rights law also embodied the values of excellence with Ubuntu, with humanity, and inspired, taught, and mentored a generation of human rights lawyers and activists the world over. I'm honored to be part of this generation, as Professor Heinz was part of the adjudication committee for my PhD dissertation defended in March 2021, just 1 week prior to his untimely passing. Just like for hundreds, if not thousands of students and colleagues before me, Professor Heinz has really been a fundamental pillar for myself and for the Geneva Academy as a whole, and we miss his emails and weekly meetings with him dearly. I was looking forward to finally being able to cooperate with him from the other side of the aisle once the defense was over and the many projects we had in mind. However, Christoph's guiding star is still very much there, and we have taken one specific message from Christoph's teaching and tried to bring that forward, taking the UN human rights system closer to the most important stakeholders, the people at national level. It is with Christoph's message in mind that the Geneva Human Rights Platform has started piloting a new UN Human Rights Treaty body procedure that, if eventually adopted by the UN, would take the UN Human Rights Committees to also meet with national actors in country rather than just in Geneva. And we could not start this project anywhere more suitable than in Africa, with the first focused follow-up review pilot taking place in Sierra Leone in December last year. There have been and there will be more pilots coming in, but I thought of sharing this small addition to the enormous legacy that Christoph has left for all of us to act upon. His lifelong commitment to advancing human rights for everyone led Professor Heinz's 6 years of service as UN Special Rapporteur on Extrajudicial Summary or Arbitrary Executions, and subsequently 4 years as member of the UN Human Rights Committee. And Christoph was not only an inspirational, ingenious, and committed human rights advocate and a generous and enthusiastic educator, he was also an extraordinary human being. I will always remember the first time I had the chance to meet him personally in 2017 at the launch of one of his many groundbreaking projects, the Freedom from Violence in Africa program. On that occasion, he had invited all participating PhD students of the program from all over Africa for a dinner and a movie night at his beautiful home in Pretoria. And together with his wife, Farika, the Heinzes hosted us with the most generous and charming hospitality, a truly homely experience. It is with this key mission in mind, that of taking the UN and regional human rights systems closer to the most important stakeholders, the people, and especially the younger generations at national level, that Christoph established the two most prestigious Moot Court competitions in the field of human rights law. First, in the early 90s, when director of the Center of Human Rights at the University of Pretoria, he envisioned the African Human Rights Moot Court competition. And while speaking with the excellent coordinator of this week's Moot and lecture, Dr. Eduardo Capapello, earlier on, I learned that the idea of the African Moot was conceived by Christoph during a return flight to Johannesburg from one of his many missions on a propeller two-engine plane. And on a simple napkin, he sketched the basis for this impressive initiative, bringing students from all over the continent to discuss a hypothetical case, in such way bridging the colonial divide in law given by the different legal systems in place. Today, the Christoph Heinz African Human Rights Moot Court competition, as it has been renamed, is the largest gathering of students, academics, and judges around the theme of human rights in Africa. His encouragement to young people everywhere to sharpen their minds and raise their voices knowledgeably and fearlessly, then continued and entered the space of a global competition, encompassing all UN regions, a sort of Olympic Games of human rights, as Christoph envisioned it. In 2009, the Nelson Mandela World Human Rights Moot Court competition was established, based in Pretoria for the first 5 years of its existence. And with the same spirit of bringing the mechanisms closer to the younger generations, Christoph was adamant that such an event should be as close as possible to where the actual mechanisms sit. As such, the World Moot has been based here in Geneva since 2014. As part of the competition, an annual Nelson Mandela Human Rights Lecture is held, and we are delighted to welcome today such a distinguished panel of experts and advocates on climate justice, representing UN human rights mechanisms, international organizations, civil society organizations, and youth activists. On behalf of the Geneva Academy, I wish you all a great annual Nelson Mandela Human Rights Lecture and our most heartfelt wishes of good luck to all teams who have made it to the final rounds of this year's Nelson Mandela's World Human Rights Moot Court competition. And lastly, I would wish to close these remarks with a short but particularly relevant quote by Nelson Mandela himself, specifically dedicated to our dear student finalists. Sometimes it falls upon a generation to be great, and you can be that generation. Thank you very much.
Thank you, Domenico. And I think with that antidote of remembering Professor Christoph Haynes, I think maybe I'll bring a little bit of my own. And I think that's a memory that many of those that have worked with Professor Haynes and have known him well, know that when you send him an email at 2 a.m. in the morning, he responds 2 minutes later. So that's something which I'll always remember and something which I'll always take with me. And I think something which perhaps is very pertinent to the role that Professor Haynes played. I mean, this moot court, he didn't only conceptualize this idea of a World Human Rights Moot Court, but really that it should be based here in Geneva, that participants should fly from all over the world. They should walk the halls of Palais des Nations. They should know exactly where it is that some of the biggest decisions in the world are being made. And I think that's a legacy that we can all keep with us and remember. And so with that, I would like to call Professor Elsabe Skuman. Thank you.
Good evening, everybody, distinguished guests, ladies and gentlemen. My name is Elsabe Skuman. I'm the Dean of the Faculty of Law at the University of Pretoria. And while we are talking about Professor Haynes was also a former Dean of the Faculty of Law. So I also have some big shoes to fill. Welcome also to all our students that I see here tonight. You have been through a tough day already, and it's very good to see you here smiling and happy. Also, a special word of welcome to everybody who's joining us from wherever you may be virtually. I believe there is quite a big number of people joining virtually. I will introduce the panelists a little bit later, but first, a few other thoughts. As you know, this is the third annual Nelson Mandela Human Rights Lecture, and this is presented as part of the 14th Nelson Mandela World Human Rights Competition. So in 2020, this competition did not take place, and 2020 was the year that I would have attended this competition together with Professor Haynes. I've just taken over as Dean, and he invited me to join him here in Geneva. Sadly, that was not to be. As you know, the world was plunged into some form of lockdown for just over 2 years now due to the COVID pandemic. But we are slowly emerging from this forced territorial, albeit not virtual, isolation. And this year, the Nelson Mandela World Human Rights Moot Court competition adopted a hybrid format. So the preliminary rounds took place virtually between 20 and 31 May, and this all culminated in you being here for the in-person final rounds taking place this week here in Geneva from today until the 21st of July. So it is quite a privilege for you to be here in person, and I know you've worked very hard to be here. So congratulations on achieving that milestone already. Allow me to pause for a brief moment here. The lockdown has put in stark relief the inequalities across nations. We have realized that access to the internet was crucial in order to receive information, keep in touch with friends and loved ones, continue with education, obtain basic goods and services, etc., etc. Name anything, we did it online. And yet, there are still vast numbers of people globally who do not have internet access, or who have very poor internet access, or who cannot afford internet access. This is unacceptable and presents a huge challenge to us. Such a basic prerequisite for participating and being part of the world should be available to everyone. Indeed, it should be non-negotiable, and history will judge us harshly if we don't remove this basic obstacle to empowerment at all levels. In addition, we also know that the next disaster might very well be related to climate change, and therefore it is imperative that we focus our attention and efforts on climate change to avert or manage future occurrences. And that will, of course, be a big part of our topic discussed this evening. The COVID pandemic has indeed been a wake-up call for the world to stand together. No single nation can go it alone anymore. More than ever before, we must be united in our response, and human rights stand central to the major initiatives in this regard. The Nelson Mandela Moot is the largest gathering of students, academics, and judges around the theme of human rights in the world. The competition reaches far and wide. It is open to undergraduate and master students from all universities in the world. A team of 2 students from each university, and also with gender diversity encouraged, is invited to participate and to submit heads of argument for a hypothetical human rights case. The 50 teams with the highest memorial grades are then invited to participate in the preliminary oral rounds. And then from those 50 teams, the best 16 teams participate in the quarterfinal, semi-final, and final rounds of the competition here in Geneva. The teams have to argue both sides of the hypothetical case, representing alternatively both the applicant and the respondent before a bench of human rights experts. And these experts are true experts. This year, the judges hail from, amongst others, the International Criminal Court, the European Court of Human Rights, the Inter-American Court of Human Rights, as well as including the President and Secretary General of the Global Campus of Human Rights. A formidable group of people indeed. And so I wish you well. We are also immensely grateful and deeply indebted to several institutions and bodies who assist the Center for Human Rights in organizing this competition, namely the Academy on Human Rights and Humanitarian Law, American University, Washington College of Law, the Commonwealth Secretariat, and the United Nations Human Rights Council branch at the Office of the High Commissioner for Human Rights. Furthermore, we also wish to acknowledge and we sincerely appreciate the financial support from the following institutions: the European Union through the Global Campus of Human Rights, the Permanent Mission of Switzerland to the United Nations Office and the other international organizations in Geneva, the South African Permanent Mission to the United Nations Office in Geneva, and the Regional Office for South Africa of the Office of the United Nations High Commissioner for Human Rights. For the University of Pretoria, it is truly humbling to be associated with such dearly valued, unreservedly committed, and internationally acclaimed actors in the human rights sphere. As a university, our vision is to be a leading research-intensive university in Africa, recognized internationally for its quality, relevance, and impact, and also for developing people, creating knowledge, and making a difference locally and globally. The Nelson Mandela Moot Court competition plays a significant part in the contribution that the Faculty of Law makes towards the realization of the vision of the university. And we sincerely thank you for walking this journey with us. The competition carries the name of the great President Nelson Mandela, a world icon embodying resistance to oppression. The values he demonstrated in doing so are universal and stand out as guiding norms for our embattled world today. Justice over inequality, dignity over humiliation, forgiveness over hatred. May we be reminded of these values every day, and may we continuously strive to realize these values in our world, in our countries, and in our local communities. I would now like to introduce the panelists for this evening's discussion, and I'm going to start with Dr. Ian Fry, who is the Special Rapporteur on the promotion and protection of human rights in the context of climate change. As always, ladies and gentlemen, the bios and CVs are far too long to recite here, so I will have to be selective. Dr. Fry is an international environmental law and policy expert. His focus has primarily been on mitigation policies and loss and damage associated with the Paris Agreement, Kyoto Protocol, and related instruments. He has represented the Tuvalu government at numerous international fora, including the World Summit on Sustainable Development, Commission for Sustainable Development, UN Framework Convention on Climate Change, and the Kyoto Protocol, Convention on Biological Diversity, the United Nations General Assembly, and the UN CITES conferences. He is the Pacific Regional Representative to the United Nations for the International Council on Environmental Law, a member of the IUCN World Commission on Environmental Law, a research associate at the Centre for Climate Policy and Law at the Australian National University Law School, a member of the Australian Association for Pacific Studies, the International Studies Association, and the International Association for Small Island Studies. A very warm welcome to you tonight, Dr. Fry. Then I would like to introduce to you Vanessa Nkata, who will be joining us online, I believe. She is 25. She is a climate justice activist from Uganda and founder of the Africa-based Rise Up movement. She began striking for the climate in her hometown of Kampala in January 2019, after witnessing droughts and flooding devastating communities in Uganda. She now campaigns internationally to highlight the impact of climate change already playing out in Africa, as well as promoting key climate solutions such as educating girls. In 2020, Vanessa was named a UN Young Leader for the Sustainable Development Goals, as well as being listed one of the BBC's 100 Women of the Year and the 100 most influential young Africans. A very warm welcome to you as well, Vanessa. Then I would also like to introduce Therese Arneson. She's the Human Rights Officer at the United Nations Human Rights Office in Geneva. She has been working on climate change and environmental issues with the United Nations Human Rights Office since 2019. She has worked for United Nations Human Rights in Geneva, Switzerland since 2014, including in its Field Operation and Technical Cooperation Division and Universal Periodic Review branch. Prior to that, she worked for a number of civil society organizations, including the Norwegian Refugee Council, Transparency International, and Human Rights Watch. A very warm welcome to you as well, Therese. And then finally, I would like to introduce Dr. Ashfaq Khalfan, who will also be joining us online tonight. He has recently joined Oxfam America as its Director of Climate Justice. He was previously the Director of Law and Policy at Amnesty International. As part of that role, he led Amnesty's effort to deepen its engagement at the global level on climate justice from 2015 onwards, including developing its policy and strategy on climate change, and established a global across-Amnesty movement project team to advance climate justice in all parts of the world. A key area of focus for him, and that includes his doctoral research, is states' legal obligations under human rights law to people outside their borders, and he was one of the authors of the Maastricht Principles on Extraterritorial Obligations related to economic, social, and cultural rights. He played a key role in advocacy to secure the United Nations recognition of the human rights to water and sanitation as legally binding rights. I think I will stop there with the introduction of the panelists. I would like to wish you all a very pleasant and enjoyable evening. Please participate, ask your questions. We've got a very distinguished panel here tonight. Thank you very much.
Thank you, Professor Schoeman. I think without any further delay, I would like to ask Dr. Ian Fry to make his opening remarks, please. Yeah, that's fine.
Thank you very much. It's a truly great honor and a humble pleasure to be speaking here on Nelson Mandela Day, one of my great heroes in life. At a recent meeting of the Local Communities and Indigenous Peoples platform that was held in Bonn in June earlier, Chief Howard Thompson, a Mohawk traditional chief from North America, told us how the elders used to teach their young to think 7 generations ahead. But he said, now things are changing. Things are moving too fast. We can only think about our grandchildren's children. This is the state of the world we have now. And this thinking about future generations is what I want to talk about, particularly around the concept of intergenerational justice as a form of climate justice. Exactly 50 years ago to this year, the international community met in Stockholm for one of the first world conferences on the environment. And Principle 2 of the Stockholm Declaration says, the natural resources of the earth, including the air, water, land, flora and fauna, especially representative samples of natural ecosystems, must be safeguarded for the benefit of present and future generations, for careful planning or management as appropriate. So here it appears that we have the first reference to this whole concept of intergenerational equity. Then we can move on and look at further international agreements, particularly around climate change. So the UN Framework Convention on Climate Change, which was created in '92, talks about that the parties shall protect the climate system for the benefit of present and future generations of humankind. So again, we have this concept enshrined in international law. The Paris Agreement does this, but perhaps slips backwards a little because it refers to the concept of intergenerational equity in the preamble to the agreement, not specifically in the objectives, though the objective of the agreement does refer to enhancing the implementation of the convention, the climate convention. So one could argue that there is a connection there. Other international agreements such as include references to intergenerational equity. The Aarhus Convention on the right to information and the Escazú Agreement, a regional agreement, makes reference to intergenerational equity. And we are seeing this concept tested in various international cases, and we can go back to as far back as 1999, where AP pollution control versus Professor M.V. Naidu. The court discussed the principle of intergenerational equity and referred to the Stockholm Declaration. There are other cases as well that make that reference. For instance, Ashgar Lagari versus the Federation of Pakistan in 2015, the Green Bench of the High Court, and it's interesting to think that they have a green bench, invoked the right to life and the right to dignity by protecting the Constitution of Pakistan and international principles, including intergenerational equity and the precautionary principle, to call for a move to climate change justice. So we are seeing progress in domestic laws around this concept, but the path is not all that smooth. Back where I come from in Australia, the full court, the federal court, in the Minister for the Environment versus Sharma, overturned a decision of a lower court, and which unanimously denied a common law duty of care to the under 18 Australian population to take reasonable care and avoid causing personal injury to death resulting from Australian carbon dioxide emissions. The original plaintiffs in this case were 8 young people aged between 13 and 17, whose claim to represent all Australians under 18. So there are some consequences of that decision, particularly in the context of intergenerational obligations. There are some issues around this whole concept of intergenerational equity. There are some questions about whether this concept applies across international borders, or whether by becoming a party to an international agreement, the concept only applies to people are bound by that state obligation. And this has been tested, and I think proven to show that there is reasonable grounds to expect the concept applies across international borders. Again, in another Australian case, in KEPCO, Bylong Australia Proprietary Limited versus Bylong Valley Protection Alliance in 2021. This was a case about a proposal by a Korean company to open up a new coal mine. And the court, the Planning Commission made a decision and was upheld by the court, which said there is a reasonable level of uncertainty in the estimation of the economic benefits of the project, and recommended the revision of the project, and that it exacerbated by the intergenerational equity of costs and benefits. And the judge, Preston, particularly referred to the focus of the case with respect to Scope 3 greenhouse gas emissions, which deals with greenhouse gas emissions beyond the immediate emissions from the coal mine itself. So it's referring to emissions that will occur in the use of that coal, and most of that coal is exported overseas. So there is reasonable grounds for that. The nuclear test case is also a useful ground for this as well, because it found the need to consider future generations. So again, it's generational equity, but it also, because of the nature of the nuclear tests, gives rise to the belief that this applies across national borders. So 50 years on from now, where are we? The recent Working Group 2 report of the Intergovernmental Panel on Climate Change clearly indicates that we are not fulfilling the contract that parties agreed to in 1992. The IPCC notes that net greenhouse gas emissions during the decade 2010 to 2019 were higher than any previous time in human history. Globally, households with income in the top 10% contribute to around 36 to 45% of global greenhouse gas emissions. Meanwhile, during the same period, the poorest half of the world's population contributed 7% of global emissions. And bringing this back to the concept of relating to countries associated with Nelson Mandela, in the past 40 years, climate-linked disasters affected more than 150 million people in Southern Africa, leaving about 3 million people homeless, and led to economic damages of more than $14 billion. According to reports, flooding in and around Durban killed 448 people and accounted to be an estimated 12 billion rand, which is around about $760 million of damage. So this is quite an indictment. And the question asks, has the international community gone to sleep on the concept of intergenerational justice? Of course, there are questions around the issue of, are the costs today to address the future costs of future generations too high to be met today? I'm not sure that that question is a valid one, but certainly there are key decision makers today who believe that those costs are too high and therefore are not acting. So, you know, with respect to the issue of the world going to sleep, what can we do about this? Recently, the Pacific Island Forum leaders in the Pacific agreed to bring forward a case brought forward by the Vanuatu government to request the UN General Assembly for a resolution requesting the International Court of Justice to provide an advisory opinion on the obligations of states under international law to protect the rights of present and future generations against the adverse impacts of climate change. This will be quite significant. To me, this seems like a superfluous question, considering that we already had that answer in various international law. But perhaps it's not just an issue of law, but an issue of awakening the global community to this obligation. So I would contend this would be a useful way forward. We need to awaken to the need to properly address intergenerational equity. And I would like to make an appeal to you to bring this forward in every opportunity you can, to litigate, and to litigate. Thank you very much.
Thank you, Dr. Fry. I think that's really a wonderful segue into our next speaker, who is Ms. Vanessa Nakate, who will be joining us online. And she is someone who's very much in the front lines, if I may use that word, of the fight against climate change, and really trying to see how exactly is it that as a community, as decision makers, can make a difference in this context. So with that, I would like to call upon Vanessa Nakate, please. Thank you.
Good evening. I would like to thank the Center for Human Rights at the University of Pretoria, all of the students who have participated in the Nelson Mandela World Human Rights Moot Court competition, and the many distinguished guests gathered tonight to honor Nelson Mandela's life and contributions. It is an honor to be speaking with you this evening and to join such a prestigious group of speakers on this panel. I only wish I could be there with you all. When I was young, I was a terribly shy and anxious girl. But I heard my father and others talk about the rain and how it had usually fallen during certain times of the year, and how the farmers could count on the rains to sustain their fields. But one day, my father told me about how things were changing. Over a relatively small span of years, my father's generation had seen the rain falling less and less frequently, and the crops were suffering. And when the rain finally did come, it would fall in great downpours, often flooding the fields and destroying the already weakened crops. Farmers that my father knew were starting to lose their farms and their livelihoods. And many people were going broke. Food was starting to become more scarce. Food prices started to escalate. And this was increasing tension amongst the people. And the situation was only getting worse very quickly. I was just 21 years old, but I could hear the urgency in his voice, and I knew I needed to find a way to help make things better. I started to carry out research about the changes in weather patterns. I am from Kampala, Uganda, a country that has one of the fastest changing climates in the world. And as I grew up, I studied more and more about how the climate crisis was already ravaging vast parts of the African continent. Africans are already suffering some of the most brutal impacts fueled by the climate crisis, rapidly intensifying hurricanes, devastating floods, and withering droughts. And yet the entire continent of Africa is responsible for less than 4% of global emissions. Many Africans have lost their lives, while countless more have lost their homes, their farms, and their businesses. And so I made a sign and I stood on the street and I held my ground. And every Friday since then, I have come back to do it again and again. In doing so, joining a global movement of millions of young climate activists. Nelson Mandela once said, "Sometimes it falls upon a generation to be great. You can be that generation." Last year in Glasgow at COP26, about 100,000 people marched in Glasgow. Many of them were young people demanding that our leaders take real action on the climate crisis. During the final days of the negotiations, I was given a chance to speak to the leaders. I challenged them to stop making empty promises. I asked them to start delivering on the commitments they had already made. I told them we had lost faith in them, but we were begging them to prove us wrong. That was over half a year ago. After COP26, I went back home to Uganda, a country that is reeling from climate-induced drought and famine that is now spreading across the Horn of Africa. Farms are collapsing, livestock are perishing, people are losing their livelihoods and their lives, and yet the news gets worse and worse. Millions of people are facing starvation in the Horn of Africa. In the Karamoja region of Uganda, more than 500,000 people are going hungry. Crops there have failed due to harsh drought, damaging floods, and landslides. One mother told doctors at the hospital that her child was not sick. It was purely the hunger that killed the child. The World Health Organization announced that 1 in 3 people across Africa are facing water scarcity. the World Bank announced that by 2050, 86 million Africans will be forced to leave their homes and try to find somewhere else to exist. And just last week, the UN predicted that Saharan flooding, heat, and drought will increase. Africa's rich array of wildlife and plants will decline, and glaciers on its most iconic mountains will disappear in the coming decades. This would be tragic enough if it weren't for the fact that the entire continent of Africa is responsible for less than 4% of historical global emissions of greenhouse gases. My fellow citizens in Uganda, and indeed the more than 1 billion citizens across the African continent, have done nothing to create the climate crisis, but we are already suffering its worst impacts. And now, thanks to a recent report from researchers at Dartmouth College, we understand that the US alone has inflicted more than $1.9 trillion in damage to other, mostly poor countries through heat waves, crop failures, flooding, and other consequences of the climate crisis. The wealthy countries in the global north must make good on their long overdue promise to support climate vulnerable countries to help them to wherever possible adapt to the impacts of this crisis. And let's be clear, the $100 billion per year of climate finance that was promised to arrive back in 2020 is no longer enough. But in addition to finance for mitigation and adaptation, the countries of the global north, which made themselves rich through the burning of fossil fuels, must now also set aside money to help for the loss and damage that is happening right now. The climate crisis is a human rights crisis. Last month in Bonn, Germany, during the climate negotiations, I sat across the table from the leading negotiators from several wealthy global north countries and urged them to create a fund for loss and damage at COP27. And this is what they told me. We see how terrible things are getting, and we understand that people in Uganda and other countries across Africa are now suffering and dying. But you have to understand that getting political support for money to help people in countries like yours is just too hard. I am sorry. I feel really bad about this. We would like to do something, but we still need more time to figure all of this out. But human beings are suffering right now. Human beings are dying right now. There is no climate action without climate justice. So I am here to say to any leader who may hear my message, I am really sorry. I feel really bad about this, but we are all out of time to figure all this out. It is time to do something. As Mandela once said, it is in your hands to make a better world for all who live in it. Do something. Please do something. Thank you.
Thank you very much, Ms. Nakate, for those words. I don't really think I can add anything to that, but what Vanessa's final words were, and that was do something. And I suppose that's something that I can also tell myself. We must do something. So with that, I will now call upon Ms. Therese Arnaz from the OHCHR to give her remarks. Please.
Thank you very much. Colleagues, friends, and dear students, I'm truly honored to take part in this lecture and to be on this panel today. I'm speaking from Geneva on a really above average hot summer day. And here in Switzerland, I've read that June 2022 was the second hottest June on record since measures began in 1864. For the planet, it's been the third warmest June on record, and we're seeing now heat waves in Southern Europe, North Africa, Central and Northern China. Last year, over 1.2 million people in Western Central Africa were affected by flooding, and the same year, climate-related disasters severely affected more than 57 million people in Asia and in the Pacific. We know that people in the least developed countries and in small island developing states are really disproportionately affected by and acutely vulnerable to climate change impacts, but have contributed very little to bringing it about. Like Vanessa said already, the whole African continent just amounts to less than 4% of global emissions. And if you put together small island developing states and least developed countries, they count for around 2% of emissions, while the G20 emits over 80% of the global greenhouse gas emissions. So that really speaks to itself. A common challenge is both a lack of capacity to adapt to climate change impacts and also to build resilience. So a fair and equal climate financing regime that would reach the most vulnerable and include them in climate action, delivering on the promises, like we heard earlier, made at COP26 last year, is really key. The nature and the scale of the climate crisis is really such so that everyone faces risk, but we know that the climate crisis really disproportionately impacts the human rights of people that are in vulnerable situations. And we really want to stress that these impacts, they can vary based on a number of factors, and they include geography, poverty, age, gender, sex, disability, migration status, religion, race, cultural or ethnic backgrounds. And where multiple forms of discrimination combine or overlap, that is often the case of people in vulnerable situations. The IPCC already stated that climate change is affecting every region in the world, and at least 3.3 billion people are highly vulnerable. That includes indigenous peoples, local communities, peasants, migrants, children, women, persons with disabilities, as well as persons living in conditions of water scarcity, desertification, land degradation, and droughts. It really is the people at the margins, both in the global south and the global north, that are left to bear the brunt of these impacts. And this uneven distribution of wealth and power within and among countries is really one of the key drivers of climate injustice. Under international human rights law, states are obliged to take ambitious adaptation and mitigation measures that limit these impacts, including by adequately regulating businesses. And in order to do so, states must implement measures that are rights-based, gender-responsive, inclusive of persons in vulnerable situations. And for climate change to really be able to advance human rights and climate justice, states should include the lived experiences and the expertise of frontline communities in climate action at all levels. Our office is working to promote a human rights-based approach to climate action with a variety of partners. We work with civil society, national human rights institutions. We support and advise member states. And some of our work is also to develop reports, to undertake studies and research, and develop advocacy materials and guidance for states in relation to climate change impacts of human rights. And we have done so with a mandate by the Human Rights Council and its recurring resolutions on human rights and climate change, and have really looked at the situation of a variety of people in vulnerable situations. We've worked on the rights of older persons, persons with disabilities, children. We've looked at gender-responsive climate action, climate-induced migration, and the impacts of climate change on health. And at the Council, this resolution on human rights and climate change was actually first adopted in 2008. And since 2015, we've had this recurring annual resolution that is really looking at the rights of different groups in vulnerable situations or thematic issues. And already we're still in July. Earlier this month, on 7 July, the Council adopted its latest thematic resolution on climate change and human rights, which was looking at specifically on the right to food and the impacts of climate change on the right to food, and mandated our office to undertake a series of reports and set up panel discussions and interactive dialogues in this regard. We also have colleagues in our field presences. OHHR has about 100 field presences throughout the world, working on addressing environmental issues and climate change. In the Pacific, our colleagues are advocating for the human rights of persons affected by climate change and supporting environmental human rights defenders, in particular working with youth, with indigenous communities, but also working with businesses. In the Sahel region, colleagues are working on directly looking at the links between climate change and migration with a gender lens. And both in Kenya and in our regional office for Southern Africa are working closely with environmental human rights defenders, supporting and promoting their work. We also saw last year a resolution adopted at the Council that recognized the right to clean, healthy, and sustainable environment. And as we speak now, this resolution has actually been brought forward to the General Assembly, where they are negotiating a resolution originating at the Council. So very exciting developments there. I won't speak much about the work that the special procedures and the different special rapporteurs have done on climate change. We now have a dedicated special rapporteur on climate change right here with us. But before his mandate was created, several other experts and rapporteurs have looked at the issue because it really is a cross-cutting issue that is impacting so many human rights. We can say the same about other human rights mechanisms. We have the Universal Periodic Review at the Human Rights Council, where we increasingly see recommendations addressing climate change. And remember that this is a peer mechanism where states review states. So it's really a different sort of pressure coming out of the recommendations made directly from states to states. We have some good examples there. We've seen Fiji, who's been really an advocate for putting climate issues forward at the Council, but there's also many other recommendations being made that aren't necessarily on climate change, but on related issues that are related to climate change, disaster risk reduction, displacement, and so on. And then finally, I really want to talk a little bit about the human rights treaty bodies, because their work, it's not only to review state conduct and I lost my chain of thoughts, and compliance with the conventions that they have ratified and adhered to, but they also issue guidance on how states should interpret the conventions and the legal provisions therein, called general comments, general recommendations. And we've really seen a lot of interesting work coming out of there, and a lot of interesting work still in the making. The Committee on the Elimination of Discrimination Against Women already issued a general recommendation on gender-related dimension of disaster risk reduction, but it's also elaborating an upcoming recommendation on the rights of Indigenous women and girls, where the right to a healthy environment and climate change are really important aspects. The Human Rights Committee already issued a comment back in 2018 on the right to life, which also really describes the links between climate change and environmental degradation and their impacts on the right to life. And the Committee on the Rights of the Child back in 2013 issued a general comment related to children's right to health, and it's currently developing a general comment specifically looking at children's right in the environment with a special focus on climate change. And finally, Committee on Economic, Social and Cultural Rights back in 2002 already had a general comment on the right to water, which include references to climate change, is now specifically looking at a general comment on land. And also, just to close, two interesting cases in terms of jurisprudence that's emerging from the treaty bodies. In 2019, we had the first human rights treaty body decision that directly addressed the human rights impacts of climate change in a case that's called Toyota versus New Zealand, where basically the committee noted that the effects of climate change in receiving states may expose individuals to violation of their rights under Articles 6 and 7 of the Covenant, triggering thereby the non-refoulement obligation of standing states. And last year, in the case of Saki and others versus Argentina, the Committee on the Rights of the Child responded to a petition by 16 children who alleged that the inadequate climate action by Argentina, Brazil, France, Germany, and Turkey violated their rights. Even if the committee held that the case was inadmissible, it stated that states can be held liable for extraterritorial human rights impacts related to climate change. So these are exciting, interesting developments to follow. I really want to stress how the UN human rights system can be a powerful tool that can be used to leverage human rights-based climate action, remind states about their obligations, and guide them in their actions at the national as well as at the global level. Our office will continue to support all stakeholders in their work to better protect people and planets from the adverse impacts of climate change, among other things, and continue to promote and protect the rights to access to information, participation, and importantly, access to justice. And if I may, I really think that this human rights-based approach and its principles of participation, non-discrimination, inclusion, justice, and equality are really in line with the Nelson Mandela spirit. I look forward to the continued discussions today, and thank you very much for having us here.
Thank you, Ms. Arneson. And I think this also links very well, first with the presentation by Dr. Fry, and the remarks by Ms. Nakate, and of course yours. It starts to create a little bit, the puzzle becomes a little bit clearer. And with that, I would like to call on Dr. Ashfaq Alfan, who's also joining us online for his remarks. Thank you.
Thank you very much, and good evening all. I hope you can hear me. Please interrupt if not. So it's really an honor. It's an honor to be speaking on an event that relates to the legacy of Nelson Mandela, and it's an honor to be with speaking to the future leading international litigators of the world. So it's a nice segue in that sense. And with the theme of intergenerational justice, I would just like to let all the the law students there know that there is absolutely no obligation on anybody to answer emails at 2 a.m. in the morning. There are many things Professor Hines worked very hard on and is remembered for, but no, please do get a good night's sleep. You will not be. It's not required. We do need the future legal leaders of the world to have a good night's sleep, and in order to be as creative as possible, including for your existing moots and the arguments you're going to be making over the next few days. Now, I'm going to focus mainly on the issue of obligations beyond borders and climate change. Now, in a nutshell, international human rights law does require states to respect, protect, and fulfill rights of people both within their borders and extraterritorially, and that has two bases. The first is that because they have undertaken obligations to respect rights in a collective way, it's obvious that if you've undertaken these rights, you cannot participate in a treaty to respect rights and then harm or allow actors within your borders to harm the rights of others to outside your borders. It does not work as a cooperative endeavor. So it's implicit in these obligations that states have to not harm rights in other countries. It's the same if on the basis of international customary law, where it's very clear as a general principle of law recognized by the International Court of Justice for many years that states cannot use their territory in a way that leads to the violations of the rights of other countries. That's set out in the Corfu Channel decision. So that's one basis, but another basis, a separate basis, it's very important that there are two separate bases for these obligations, is the explicit obligations of international assistance and cooperation that are contained in most human rights treaties. All of the treaties that relate to economic and social and cultural rights, and then many of the other ones relating even to torture, etc. And of course, in the United Nations Charter. The extent to which these rights apply to climate change, or these obligations are applied to climate change, have been developed much further. I would like to refer people to the Master Principles on international law relating to economic and social cultural rights, which are not legally binding, but which provide a codification of these rights, of these obligations, tries to set them out in a coherent way, drawing on what is contained in international law. Now, the international human rights system has taken this and applied it. It has the Inter-American Court on Human Rights, the African Commission, and virtually all of the human rights treaty bodies. The Inter-American Court explicitly applied it in the case of climate change, saying that states have an obligation to avoid transboundary environmental damage that can affect the rights of people outside their territory. Now there have been various statements by the various treaty bodies, and it has been applied in the Sachi case, as was just mentioned by Therese. The treaty bodies on discrimination against women, on economic and social rights, on migrant workers, on disabilities, and on children's rights have said that failure to prevent foreseeable human rights harm caused by climate change, or to regulate activities contributing to such harms, could constitute a violation of states' human rights obligations. And so this means that states parties to these treaties have to reduce greenhouse gas emissions, contribute to phasing out fossil fuels, promoting renewable energy, and to reduce emissions from the land sector. They must also regulate private actors and discontinue financial incentives that are not consistent with low greenhouse gas emissions pathways. So that's the legal basis. Now, what I'm going to try and do is set out the specific obligations in regard to extraterritorial obligations. One main one is, of course, to reduce emissions to the maximum possible extent and through a just transition while maintaining rights. Obviously, emissions, states need to phase out fossil fuel emissions and methane and other emissions. They can't stop it immediately because, of course, it has to be done in a way that respects people's adequate standard of living, food, etc. But it can be done quickly, and the pathways have been provided by the Intergovernmental Panel on Climate Change. But states obviously have to allocate the resources for that. So that's not an obligation only to their own people; it's an obligation to people outside their borders. Rich and industrialized countries has already been said by the fellow speakers, because of their historical disproportionate contribution, they need to achieve zero emissions much faster than developed countries as a result of, number one, their disproportionate contribution, and number two, their greater ability, the level of technological capacity, financial capacity to make this transition quickly. I'm saying setting out on a legal base, in a legal framework, because these are legal obligations, and they have been litigated quite significantly in many countries with tremendous effects, as seen in Germany and Netherlands, as a couple of examples, at least in regard to emissions reductions. The other four core broad obligations I'm going to talk about. The second is to provide finance for loss and damage and adaptation. That's part of the right to remedy. Because of the harm caused, they have to contribute for their share the harm. And it is possible, and many people have done this. They've quantified what it means in terms of percentage contribution of each country, as was just mentioned by Vanessa, for example. The problem is that currently there is no commitment, not even a political commitment, to provide funding for loss and damage. There's a commitment that developed countries have set out to provide 100 billion between 2020 and 2025, which is meant to cover assisting developing countries to reduce emissions and to adapt. It doesn't specify in what proportion, and most funding has been primarily towards reducing emissions and disproportionately less for helping developing countries adapt to the consequences of climate change. So you can see already there's a bit of a self-interest. Developed countries, wealthy countries, are funding the bit that actually benefits them most. There's been at the climate conferences, there's been more of an acceptance of the need to ensure a balance between mitigation and adaptation. But no commitment thus yet to assist people whose lives have been harmed, like their fishing gear, their hospitals, schools destroyed. There's actually no formal commitment to provide funding for that, which is just staggering when you think about it. And if you look at the cost of it, Oxfam had a report this year that estimated that the economic cost of extreme weather events last year alone was 329 billion globally. That's twice the amount of total aid given by rich nations to developing countries that year. So it just gives you a scale of just how little the funding challenge has been grappled. So that's the second one, finance for loss and damage and adaptation. The third is provide finance for mitigation. The reason I'm separating that is because legally, that's not only that is the legal hook for that is the obligations of international assistance and cooperation, positive obligations to assist developing countries reduce their own emissions. That's one. The other is rich countries, in order to protect their own people from the effects of climate change, the only way that is feasible is for them to not only meet financial needs themselves, but to provide funding to especially the lower income and the lower middle income developing countries who cannot shift to renewable energy as quickly as possible without that funding that has been provided. So it's actually a territorial obligation that requires them to do this. I don't think that a case has been made legally, but it'd be interesting to try and to see what will happen in some of the litigation that's coming up, including potentially in the various litigation that's coming up even in developed countries. So just in terms of the scale, so we've talked about the 100 billion figure, and Vanessa already said it's not enough. If I can try and quantify that, of the plans, what's called the national determined contributions, meaning effectively the climate plans of states, of 153 of these plans, half of them were costed. So 78 of them were costed, and that cost is about 5.9 trillion a year. So that's a pretty large amount. But if you think about it, that's about 4% of the world's economy that would be required for this. So that's not something that lower income countries can raise themselves. This needs serious financing, including from having new sources of financing. And there are billionaires who are making billions every second, and who could be tapped as a source for that once people have come to grip with it. So that's the the financing for mitigation. And the fourth is to just talk about the quality of financing. A lot of it is provided, about half of it has been provided on non-concessional terms. So that's already a problem, because in a sense, countries that are being harmed by damage caused by other people are having to borrow money on commercial terms to fix it, and then they have to pay back, which is completely unjust, and I would argue is contrary to the legal obligation of remedy and international assistance and cooperation. Of course, I should mention that there is also the issue of ensuring that human rights are respected in the provision of assistance, so that the conditions themselves don't harm human rights, like if austerity conditions are tied to loans, or if projects are implemented in ways that impinge on the rights of indigenous peoples, local communities. There is a huge challenge, because a lot of the plans of developed countries and of corporations envisage a huge amount of land being taken for to store carbon, or even for afforestation, with no consideration of the amount of land that's needed for food production, in a situation where we have a food price crisis. So there are a lot of issues there, of things that are not being squared properly, where a holistic view of all human rights are just not being taken into account. So why? So I don't want to end on a very pessimistic note. There is the challenge that the political negotiators were telling Vanessa, which is very real, that there is not a huge amount of political support for the large amount of international financing required. That needs to be generated. It needs leaders to stand up, tell the truth. It needs civil society in the global north to really invest into telling this and willing popular support for the amounts of global thinking that are required. And it probably will need partnerships between civil society from the global north and global south. That's most likely to be effective in asking for the right things, pushing for the right things. If I can end on a note of optimism, 10-20 years ago, there was no, all the treaty bodies hadn't spoken out this way. The Inter-American Court hadn't spoken out this way. Now we are seeing litigation by Peruvian farmers in German courts, Indonesian farmers in Swiss courts. So there's, there are things are happening in this score. When I did, and I'll conclude on this note. When I did my PhD defense on extraterritorial obligations, I had my examiners ask me, "Is this an area ripe for litigation?" And I looked at them. They were elderly gentlemen, and I said, "In my lifetime, perhaps." Of course, and luckily they did pass me. They didn't take that too personally, but I was actually wrong, because they're still very much alive, and we are seeing the beginnings of the extraterritorial litigation that are coming. So we do need an important push, on the streets by Vanessa and others, and you, and in the courts, and in academia. So we'll get there, but it'll be a long slog. Thank you.
Thank you so much, Dr. Khalfan. I think what I got from that was that we need to reconcile academia with the policymakers and with the lawyers and the activists, and bring them all together into this interesting melting pot. So thank you for that. So we're going to go directly into the panel discussion, which is the last segment of this evening. And this discussion will be moderated by Ms. Mariana Bolshakova, who is the Regional Coordinator for Environmental Law and Governance at the United Nations Environmental Program. And her co-moderator will be Mr. Lloyd Couvert, who is the Assistant Director at the Center for Human Rights. So they have both prepared a question, or is it questions? A question which is which is directed to our panelists. And once they ask those questions or question, and once those questions are answered, we will then open the floor for questions from you and also from those online. And so without any further ado, please, Mariana and Lloyd, you have the floor.
Yeah, it is. Yes, good afternoon, everybody. And yeah, this has been, it's always really interesting. This kind of conversations are you always learn something new, whether it's numbers or approaches. When we were negotiating the Paris Agreement, we spent a lot of time discussing where human rights language will go in the text. And the reason for this is was gaining the momentum, particularly here in Geneva and the Human Rights Council. The discussions on the interlinkages between human rights and climate change were very active at the time. But in the climate process, this has always been a bit of an orphan issue. And partly it's because it is a very technical process where people come in and they discuss all kinds of emissions and formulas and things like that. A lot of the negotiators are looking more at the technical side. But also because there are concerns. And part of those concerns in the negotiations on Paris were the issues of conditionality. And so I'll explain that before I'll pose the question. The conditionality issue is you do have impact of climate on human rights and rights of individuals and everyday lives. But you also have the impact of climate mitigation and adaptation projects and technology being used. And I think that's what the previous speaker was just talking about now at the very end of his intervention, that also comes sometimes at the cost to human rights. An example of that was a clean development mechanism under the Paris Agreement, where developed countries could sponsor projects that led to emission reductions in developing countries. A very good idea in itself, and then get the credits for it and trade those credits on the market. But in the end, there were problems in some of those projects where human rights safeguards were down to the local government to implement. There wasn't a check process within the mechanism itself. And there were some allegations of human rights abuses in the countries, people being evicted from the land because that land was being expropriated to implement the project, to put biocrops or to put a dam or something like that. So when we negotiated Paris, there was a lot of concern from developing countries that they didn't want to see language of political nature coming within the finance or technology transfer. And that included some of the human rights considerations being put into the conditions for availability of finance, technology, and other support mechanisms. So my question to the speakers, and I'm looking at Jan, it's not an easy question, but also at others. Where are those entry points? Because we do need to look at this. We do now have language in the preamble of the Paris Agreement. It gives us a starting and jumping point. How do we address, where are the entry points in the current financial mechanism arrangements, in the technology transfer arrangements, but also in the hopefully what will be a loss and damage framework. We do have a mechanism now, but hopefully someday will be a fund. Where will there be entry points for human rights in very practical terms, and how to balance this need to address human rights, but also take that concern of not politicizing finance that developing countries have?
So that perhaps I could just also pose my question, and then you can take both of them together. I will not be very provocative, but I will sort of perhaps act as a devil's advocate in a way, because my question is not something that it's not an issue that I myself subscribe to, but it's an issue that is being raised by certain states, particularly in the global south. And I would like to hear the views of the panelists on that. So the first issue, I think, Therese, you spoke about the human rights-based approach to climate change from the UN's perspective. But I think, just to carry on from Mariana's thoughts, there's a feeling that, human rights language is being used to sanitize what is perhaps clearly a political and economic issue. We have had figures being thrown around, trillions of dollars, billions of dollars. We have heard about the negotiations at the COPs that are taking place. That perhaps that's where the real business is happening, and that the human rights-based approach might not take us anywhere. I would love to hear your thoughts, Therese, on that. How correct are some of these perceptions? Secondly, the issue of I think it was Ashford who spoke about contribution to phasing out fossil fuels, reduce emissions, regulate corporates, and discontinue incentives, and so on and so forth. When you look at what is happening on the ground, one gets worried because I think quite recently in the United States, we have seen some kind of regression where some states approached the courts arguing that the federal government should really not be regulating coal-producing companies because it will have an impact on profit, it will have an impact on employment, and it appears that the court agreed with them. And that for me is a bit worrying when you then look at it in the context of the commitments that have been made about climate financing and so on and so forth, and helping poor states to move away from fossil fuels to renewable energy. It's also worrying when you look at, despite the, I think, pronouncements by the Chinese government that they will actually help in terms of reducing fossil fuels and moving to renewable energy. And then you see China playing a big role in actually exploiting core resources, especially in the global south, but also having huge coal plants in its own backyard. You then begin to question the commitments. How sincere are the wealthy nations when they make these pronouncements that they are willing and are committed to assisting the poor nations mitigate the impacts, the devastating impacts of climate change? I think we have heard that from the various speakers, particularly Vanessa. I think she mentioned a lot of that. My perhaps final, it's one question in three. my final question, Dr. Fry. I think your clarion call was litigate. In some of the attempts that the Center for Human Rights has taken, trying to train lawyers on climate justice litigation, we noted that there's a dearth of expertise and knowledge on climate justice litigation. I also subscribe to the view that perhaps that is the future in terms of tackling the climate justice issues together with the human rights-based approach. But what can be done? And I think perhaps this is the beginning, because we've got here in the room legal minds, young legal minds that will be going out into the world. What can be done in terms of equipping lawyers to do litigation at the domestic level, but also more importantly, at the regional and international level, together with cross-border litigation. Thank you very much.
Yes, some challenging questions, I guess. I was certainly in Paris negotiating around the issue of human rights and where it would be located in the Paris Agreement, and that was a real challenge. And there are a number of perspectives on that issue. Certainly, there were some developing countries quite nervous about having human rights in the operative section of the Paris Agreement because it placed too much of an obligation on them to consider that. Particularly some of the sort of, how shall I say, some of the higher greenhouse gas producing developing countries were concerned that if a human rights lens was placed on them, that there would be concerns. And they didn't want to have that obligation on them. So that was an issue. There were certainly some concerns amongst some of my colleagues in the least developed countries that human rights issues were advancing some issues, particularly around LGBTIQ plus issues that weren't appropriate to be brought forward. So there was some concerns around that issue as well. So, you know, where we were going to place human rights is quite critical. And as I said, I think we moved backwards a little when we considered in the Paris Agreement, because it's not in the operative text. But we're starting to bring that forward, and through the Office of the High Commission for Human Rights, you know, who have formed a sort of Friends of Human Rights and Climate Change group that we meet in the margins of climate change meetings. We've been trying to advance human rights. And certainly I was involved in the negotiations of Article 6, which refers to the market-based mechanisms. And we worked very hard to get a reference to human rights within that section. Based on the experience of the Clean Development Mechanism, we know that some mitigation activities do infringe human rights. And clearly, if we only look at hydroelectric dams, we know that those sorts of dams, you know, particularly in China is by far the biggest developer of hydro dams. There are serious human rights implications and downstream effects of those dams. People are being displaced by the dams, the access to water downstream. I was reading a paper saying that, you know, downstream countries along the Mekong were suffering water shortages, even though there wasn't a drought because of the domination. And you'll see, you know, discussions around that on the Nile River Basin as well. And I spoke with Indigenous peoples groups who were also concerned about dams affecting their rights to food, to water, you know, to the right to life because of the effect of the flow of those dams. So there are serious sort of mitigation connections there, and some countries don't want to address those. So there are challenges in placing human rights into the context of climate change. But it's clearly an issue that needs to be brought forward, particularly in the loss and damage area. We know that there are, as we've heard, there are huge impacts on the rights of people to food, water, life, as a consequence of not taking enough action on climate change. So we need to apply the human rights lens to those issues, to advance those issues. So that's a critical area. And perhaps to sort of move into your questions. Clearly, there are issues around, you know, if we are moving to green economies and moving people out of the fossil fuel industry, we have to provide just transition for those people. So there are human rights implications of moving people out of a fossil fuel economy. and we have to be aware of that. It's certainly a particular issue in South Africa, where we have to find alternatives to the workers, to their families, and to their communities who are going to be affected by this transition away from fossil fuel industries. So there are clearly areas there that need a lot of work to be developed in recognising the human rights implications as we move towards green economies as well. So maybe that's addressed some of your issues, and I'll let you.
Thank you. Thank you so much. Thank you for all these questions. They weren't all straightforward to me, but I'll give it a try. I think, first of all, the climate crisis is really caused by greed. It's caused by corporate greed and by human greed. So in terms of court cases and whether or not you should regulate profit, I think it speaks to itself, the fact that we are where we are today. What does human rights mean in terms of balancing it with other concerns? Where are they taking us? I think that it's very clear that we're not going anywhere without human rights, because the specific examples that both Mariana and the Special Rapporteur mentioned about where climate action is really can be harmful to local communities, to indigenous peoples, are precisely those cases where we see climate action that aren't undertaken with a human rights-based approach. And just to demystify that concept of a human rights-based approach a little bit, it's just about people. And rights are about very simple things. Human rights are about very simple things. So the sort of opposite attempt to politicize the human rights discussion and say that, oh no, over here or over there or wherever you are, human rights, people aren't interested in this, or this is a construct from somewhere. I don't think there's anywhere on this planet where people don't want to eat food and breathe healthy, clean air and drink clean water. So I mean, it's really about the very basics. So I think it's the other way around. It's made complicated, but it isn't complicated. And in terms of the siloed approach, the discussions of whether human rights has a place in climate negotiations, obviously we also, from the states who want to put it that way, we see the opposite at the Human Rights Council. We see the discussions and negotiations of Human Rights Council resolutions where the question is made whether, climate change is an issue for the Human Rights Council. And I think that, since 2008, we've come a really long way, both at the council, both thanks to all the human rights mechanisms and all this other body of research that is emerging from the IPCC and so on and so forth, where you can't really put this question into doubt anymore. It really boils down to what was said by Ashfaq before, that states have an obligation to prevent foreseeable human rights harms, and damage to climate change can, may, and has caused to human rights is already very, very clear. Maybe I'll stop here because there are other speakers that may want to speak as well. But yeah, very, very interesting questions. Thank you.
Just to check what's.
Sorry, I missed one of your questions, because and this is around litigation and how do we develop this litigation. And I just want to indicate that there's an energy charter treaty where fossil fuel industries are suing governments for taking action on climate change. In fact, they're spending more money litigating under the Energy Charter Treaty than there are litigations against these companies. In fact, there was a claim made against Mozambique, of all countries, under the Energy Charter Treaty for its actions to reduce its emissions. And the costs awarded against Mozambique were enormous. And this is, an absolute tragedy and travesty of justice. But like you were implying, people like you, lawyers around the world we need to develop systems to build capacity so that people can litigate. We've got to provide systems for paralegals, for local communities to have the necessary information to run cases. And I was recently on an online workshop run in the Pacific for Pacific judges, and to try and get them to understand, the cases that are out there that they can draw upon to make decisions. So there's a lot of area where we can develop capacity in developing litigation, and it's it's universities like your own who are doing a great job in doing that sort of work. Thank you.
Thanks. I just wanted to check if Ashfaq had anything to add, because
I'll make a few quick comments. On the, one thing to emphasize is that the fact that human rights is in the preamble of the Paris Agreement, it's actually very unusual to have human rights in the preamble of a multilateral environmental agreement. If I'm not wrong, at least I'm quoting John Knox here, the previous Special Rapporteur on Environmental Protection on the right held environment, that it's actually, it may be the first. But so certainly very unusual, and it is it does go to show a bit of the gulf between the environmental community and the human rights community, that it was considered so controversial. What's really interesting is that in the development cooperation community, there's much more familiarity with human rights concepts, even in the aid effectiveness agenda, which is all about transferring power of control of budgets to the countries themselves, to global South countries themselves. Even there was the recognition that there is mutual accountability for commitments related to human rights, gender, disability. That was agreed at the Accra agenda on aid effectiveness. So there's more acceptance that these principles must be reflected in the way in which development assistance is implemented. One thing I should say is that in the negotiations of the Paris Agreement, some of the resistance to human rights language also came from developed countries, in particular, the US and Norway, and countries in the middle like Saudi, which don't receive any aid, but had that sort of allergy towards the use of human rights language, either in general or in environmental context. So it's a bit complicated there, and let's recognize that part of the resistance does come from the bad faith use of human rights by developing countries. I mean, George Bush used it to justify the invasion of Iraq. Certain countries, if they don't like a law, say an LGBTI suppression law, they cut food aid, which even many human rights organizations such as Amnesty oppose that. You don't achieve the rights of one people by punishing another group of people. So that I do understand a bit of some of the hesitation because of the fear that human rights would be weaponized in that way. And so what we need to get into positions that we're not talking about using human rights as a sword, but really as a protection mechanism, to ensure that where international assistance flows towards climate and other areas, that those funds themselves do not cause human rights violations. In terms of Lloyd pointed out the hypocrisies of the US and China, and what I would say is that it's a mixed picture. You have a lot of actors who are strongly resisting the progress, such as the states in the US that went to the court to try and resist this progress. But at the same time, you do have a lot of states, like individual states, California and others, who are making tremendous progress. And level of emissions in the US are moving down, partly because of just because coal is uneconomical, but also because of these steps that some actors are taking. Some European countries are doing tremendous things in terms of their movement towards renewable, and like Finland and Denmark, for example, taking significant steps. Even China's progress, I would say, is mixed. Tremendous investments in renewable energy. In some cases, obviously, unfortunately, it's a mixed picture, right? If you look at forced labor in Xinjiang. So it's a mixed picture. And I think it applies everywhere. And so the struggle really has to continue at every level, in every country, in every continent, in every locality. The last thing I'll say is on litigation, that just for people to remember, it's now well understood among the social litigation community that litigation should almost always be done as part of a wider social movement struggle, and that the most effective transformative litigation has been where as soon as the court case was won, there was a mobilized community of people who were willing to push it through, because a decision by itself often isn't sufficient. You need the long-term implementation that's required to move it from the decision to implementation. Of course, South Africa is a great example of that. Thank you.
Thanks very much. And I'm told we've got a few minutes for more questions. So yeah, okay, 1, 2, I think I could take probably 3, and 1, 2, and 3, and then so the lady will put at the back in the white shirt.
Okay. Is it fine? Can you hear me? Okay, then I will just ask the questions. Okay, maybe it doesn't work when I'm a bit far away. So, first, can you hear me now? Oh, okay, yes. So, first of all, thank you so much for this lecture. It was really helpful, I think, at least for some people, at least for me. So my question is about that you mentioned in human rights advanced issues, and I have a question about it. So human rights advanced issues, what about the other different advanced issues for the countries which are dealing other human rights issues, for example, Ukraine or the Caucasus region? And even though they are the part of the Paris Agreement, they have more difficulties to dealing right now. But at the same time, for example, in the North Caucasus region, the mountains are different right now, and the climate changed a lot, which really will affect a lot in the future, and there will be a lot of damage. But at the same time, they cannot really afford to deal it right now. So my question is that what do you think? What are the policy for them? And if there's any different, how you see this, and how can you help them, or what are the more issues, like specific issues for this kind of countries? Thank you so much.
Okay. Can be heard? Yes. So my question is first on the human rights-based approach. Do you think there is need for us to extend it a little bit more than that? Because it seems to be more anthropocentric rather than ecocentric. And with the current discussion, for example, the right of nature, and giving an example, in Africa, only Uganda is the only country that has the right of nature within its laws under Section 4 of the National Environmental Act. And even that requires a regulation in terms of operationalizing the same provision, but it appears that has not happened. So don't you think it's also important for us to be able to extend the human rights-based approach, not only within anthropocentric, but also within the ecocentric aspect? In the same regards, as far as the states being skeptical, don't you think there's need for us to be able to have more of a balance? Because states sometimes take the notion of, well, we try to fight climate change, but then we are sued, and then we incur a lot of expenses. And I'll give an example of Vattenfall in Germany, when Germany decided to close down the nuclear facilities. And you saw what happened. They were being sued for billions of dollars until they had to settle the matter. So that shows why states are skeptical in terms of why they need to take an approach or a certain perspective in terms of fighting climate change. So how then do we
make sure that even at the same time we're fighting climate change, but we're considering all stakeholders for the purpose of the political will to be able to achieve the goals we want to achieve. Thank you.
Hi, thank you. I also had a question about the human rights-based approach. And it seems that everyone's in agreement that at a higher level, there's a common purpose between human rights-based approaches and climate change-based approaches. But at the micro level, in terms of how the two regimes of law interact, there are problems. And so, for example, with the principle of intergenerational equity, that works in international environmental law, but it doesn't really translate to the rights focus of international human rights law because there are issues of standing for future generations and admissibility concerns. Similarly, the issue of extraterritoriality that works in climate change law because it's global cooperation, but it doesn't really work in an individual rights-based focus. What are the ways to resolve these sort of micro issues of difficulty in reconciling the two different modes and legal forms of the areas of law?
Yeah, so I think we'll allow the panelists to respond to those, and then we'll take 3 more questions, and then we close. Thank you. After the response.
Well, thank you. For the first question around Ukraine and the Caucasus area, obviously there are issues that are not related to climate change, but there are human rights issues there. So I can't really comment on those in that regard. Nevertheless, there are clearly a lot of linkages between climate change and issues around climate change being a driver of wars, I guess, is what we could say, and certainly security tensions. There is an argument that the Syrian war started with a 9-year drought where people were displaced from the rural areas into the urban areas, and that caused urban disturbances, which helped precipitate some of the tensions within Syria. Certainly within the Sahel region, displacement of people in the Sahel has created issues around peace and security, and that was picked up by the Security Council. So there are linkages between security, peace, and human rights and climate change issues that clearly need to be considered. With respect to the issues around the rights of nature, clearly this is also a particular issue that should be considered as well, and not so exclusively. And perhaps the right of nature is a poor cousin of the human rights discussion, I guess. It's certainly been considered in the Convention on Biodiversity and around those issues of rights of nature. It also comes into the issues and discussions around the debate about ecocide and whether the International Criminal Court should be considering a new definition that incorporates ecocide, and that bridges the sort of the rights of nature plus the rights to human rights around a safe environment. So there are certainly issues there. Of course, there are consequences of litigation, and we have to be mindful of those consequences of litigation, that they don't create additional problems. And so, cases have to be thought through carefully to ensure that they do bring about, reforms that we are hoping, to drive. And certainly, the German case, as you mentioned, is an interesting one, whether that case, drove the right sort of reforms that we're looking for, and whether there are implications. As far as the issues around rights-based approaches, whether they properly address all the issues that we need to consider. Of course, it's a balancing game, isn't it? I mean, we have to look at the implications of climate change on the rights of people, to the rights of food, the rights to clean water, etc. So there is obviously a need for human rights lens around that, and we have to maintain that observation. But clearly there are issues around whether rights-based approaches deal with some of the broader issues, and you mentioned issues about provisions of standing and etc. And this is a critical issue, and it's certainly one of the issues I want to look at in my mandate, is how to improve standing provisions for youth and children to be represented in courts, to recognise their rights in courts. And we've seen various cases where youth groups have taken cases. Some have been successful, some have been denied standing, and so we have to look closely at those issues to find out why those groups have been denied standing in certain cases. So it is an issue that certainly I'll be looking at.
Thank you so much. I knew we would get difficult questions from the students. I'll try to add to what the special rapporteur said. And on the first question, without going into the country situations and the situations in different territories, what the special rapporteur said really about climate change as a driver of conflict or a contributor to tensions, and also to say a little bit more about how the UN system is going about addressing this more practically. For example, in his call to action for human rights, the Secretary General really highlighted the links between environmental issues and human rights, and mandated the UN to better work at country level, to do better work on the ground, jointly with civil society, with national institutions, to promote and protect civic space, also in relation to environmental issues. In our common agenda, which is sort of a vision of the Secretary General of where the UN is and where it's going in the next years, you can see that really environmental degradation and climate change, these sort of concerns are really elevated along with conflict, famine, the sort of traditional issues that you would see the UN work on that the UN was set out to work on. So I think that in this sense, without only talking about the human rights-based approach, you really see these interlinkages being made. We're trying to do it ourselves in our work. Our office signed a memorandum of understanding with UNEP a couple of years ago, so as to really bridge these two worlds. And you see it in the work of UN country teams already on the ground, where after the UN development system reform, that revised the setup of these UN country teams, where you have a resident coordinator with different advisors in her or his office with specific competencies. Now we also see a model in there, not in so many countries, but for example, in Somalia, we've already seen it, of something like climate or environmental security advisors. So I think you really see these developments and these interlinkages go hand in hand. I think it's an exciting moment in history because we see the developments with Escazú Agreement, environment, human rights, defenders, for all of the Latin American and the Caribbean region. But you also see it with the Aarhus Convention, which has already been in place for decades, with the new rapporteur specifically nominated to work to protect and promote environmental human rights defenders. Just to add to answer to this question about, you mentioned the case of Germany, where do we go in terms of a just transition? I mean, I think we can all recognize that's really one of the main challenges for governments. And I think this also illustrates the links, because we're talking about how to reduce pollution, how to stop destroying the environment, and at the same time protecting people's livelihoods. And that's really a human rights question. So I'll stop here because we're running out of time, and maybe we have online participants as well who want to add.
Okay, no, thank you very much. I mean, difficult questions have been asked. So I see two more hands. Look, what we'll do, yeah, okay, 1, 2, 3, 4. What we'll do is that we'll take 3 more questions, And then there are refreshments that have been prepared for us. You can then also get to ask some of the questions that you have directly to Ian and Therese during the refreshments. So we'll take three more questions and then we will close. Thank you.
Thank you. My question is more related to how do we shift or create incentives so that in the logic of how business works, how do we make the shift so that taking care of the environment is profitable, you know, because that's to some extent it's the opposite. Like to consume, to produce is to consume, and to consume is to impact the environment and nature. So how do we make this shift? Because also law follows reality, and I think this also requires the embracement of this awareness of what we're doing as a species. And as you said, like it's this incentive like might be simple, because in the end it's like, okay, the incentive is that we're not going to die, you know, like we're going to survive as a species, or like it is really simple. But how do we make the shift so that in reality and in action, like the major causes of climate change, corporations like see incentives to work on this direction? Thank you.
Firstly, thank you to all the speakers on the panel and your moderators for the time tonight. I'm sure we've all really appreciated hearing from you. I wonder, we're speaking so much about a human rights approach to climate justice. Do you see what, in your view, are our options for jurisdictions that don't have the appropriate human rights mechanisms or frameworks in place? And the one that comes to mind for me is Australia. Because Dr. Fry, you mentioned the case of Minister and Sharma. And I think, unfortunately, all that showed us was that turning to common law, negligence, or administrative law could not create any positive obligation to enforce climate justice. So how do we push for a human rights approach to climate justice in those jurisdictions?
Mariana is persuaded me to take the fourth question. So 3 and then 4 at the back.
I thought I'd try to have you end on a more positive note, if that's possible. We all know sitting here that the fight for human rights is a never-ending struggle, but nevertheless. And I also wanted to connect to the Moot court that most of us are participating in, where two of the main issues are extraterritorial violations by a state in the context of an armed conflict and violations by corporations in armed conflict. And it seems that even though we see cases now against, at least from my perspective from Sweden, against Lundin Oil and Ericsson for violations in Sudan and in Iraq, it's taken quite a while for us to hold corporations and states accountable for extraterritorial violations and violations by corporations. So turning then to climate justice, how do we hold states, seeing as it has been so hard to hold states and corporations accountable when there is a clear and direct link between corporations and states and the violations themselves? Missile strikes launched against foreign territory, or private military security companies detaining people abroad. Since there's that clear link, but it's still been difficult, what is the prospect of succeeding in these litigations that we've been encouraged to take part in within climate change, since those linkages might not always be so clear to establish? So if there is any positivity on that note, that'd be highly appreciated.
last but not least, hello everybody. Food is coming, don't worry. I'll try to be very quick, but I was listening to what you were saying about environment and the need that we all have to take care of environment and under human rights based approach. But you know, I come from Brazil, and recently we've had like this of killing human rights defenders. So it's not about promoting human rights defenders, but also protecting them. And I speak as a person who personally is currently afraid of, you know, I'm going to work at an ONG and fight for our waters and our trees. And because I don't know if you know, our government actually gives way to the deforestation and the destruction of vast destruction of our nature environment. And also the indigenous people, as you mentioned, is suffering and dying. And I think you've heard about Bruno, the indigenous people who has been killed along with Dom. So in fact, I just wanted to know if there, or what are the measures that might exist to prevent this kind of violence, or even fight against this kind of violence against the defenders of what we're trying to do, because it's many levels, as you said, like there are many levels of difficulties, and I think this is one of them, to form and ensure that we are also safe. We have food and are alive to eat, because this is the important thing too. Thank you.
More difficult questions, Ian and Therese. So, and I think Mariana will give us, I think, the last word, because she's working in this area, and then we then close. Thank you.
Well, thank you. I feel like I'm, being pushed against the wall here. It's good. It's good to get such good, challenging questions. On the first one on incentives, clearly I'm not an economist, but we can see some useful examples. We now know that Denmark is claiming to going to be 100% renewable in a very short period of time. So there's got to be incentives for the Danish government to do that. And clearly there are economic incentives. I think the Ukraine war has shown that countries are now seeing, the responsibility of energy and self-reliance on energy is going to push the renewable energy market quite quickly. It will suffer immediately. I was speaking with some rights holders in Colombia who were telling me that a new coal mine has just been, an old coal mine has just been reopened to provide the necessary coal for Europe to meet the shortfall in energy that they're suffering there. But it also pushes them to be self-reliant on energy, and the best way to do that is primarily through renewable energy. So I think there will be incentives around that being driven. The issue around the human rights approach and how to deal with that, particularly in jurisdictions that don't have a strong record in human rights, is a challenge, and we know that, and there are certainly First Nations people are challenging a new gas development in Western Australia, and we're here a couple of weeks ago in Geneva speaking to the Human Rights Council about that, to get some consideration of that. And this is the challenge: is where is the adequate recourse if there isn't adequate national legislation to deal with those issues? So we have to encourage governments to develop the appropriate legislation. Again, Torres Strait Islanders seeking issues around their situation. Some of it comes with the positions of judges And as we've seen in the United States recently, very conservative judges have rescinded some serious questions and have pushed back on the Biden's administration, climate change agenda. So that there is an issue about appointment of judges that needs to be considered. And can we find a system that is not so political in appointment of judges? And that's a real challenge for us and how to do with that. And looking at the sort of issues around how do we hold states accountable for international injustices and human rights implications? Well, we've just got to explore that, that issue further. And this is becoming an increasing issue, particularly in the climate change agenda, certainly in the whole net zero agenda as well. I had a couple of students from Cambodia who were looking at the impacts of a carbon offsetting project being undertaken by Microsoft. So they were doing an offsetting project of planting trees in Cambodia without any consultation of the local communities at all. And so there is this whole, corporate agenda of going to net zero, but there are serious human rights implications around the word net, and how that's being offset. So there are issues that we have to consider, and do we have to develop more legal provisions to deal with this, the state rights principle of no harm to another state, and whether we have to develop that further into treaty law. And finally, the issue of human rights defenders is a critical one, and the challenges, for within governments that have administrations that do not respect human rights defenders. And we've seen certainly some world leaders in recent times who have been, acting seriously against human rights defenders. I think now the Philippines now is elevated above Brazil in being the case where the most number of disappearances of human rights defenders, and we can look at the administration there. So that we've gone through this sort of dark period of having world leaders who are disrespectful of human rights defenders and disrespectful of human rights, and I think we've got to find ways of making them accountable. Should they be brought before the International Criminal Court, for their actions, and certainly that's sort of one point of recourse I think we should be looking at. Thank you.
Thank you. I'll start with a question about how to make protecting the environment profitable. I mean, with all the greenwashing that's out there, you look up the website of any oil company and they look like they're doing nothing but protecting the environment. It's all green. So I think being seen as protecting the environment and being seen as protecting human rights is profitable. The question is, how do we actually make that happen? Was looking at the website of the Norwegian Pension Fund the other day. They have stocks in 1.5% of the listed companies in the world, more than 9,000 companies. It's a pretty big investor. And what they've done is that they've put out these sort of expectation documents for the companies that they invest in. And they say, listen, no one wants to be associated with this and this and that anymore, including environmental degradation, including huge emissions, including human rights violations. And really put it forward that the power is also in the hands of investors and consumers. I feel a little bit on a personal level that the link, we're still lacking a link between feeling direct responsibility for whatever we buy and whatever we consume. I feel it's a typical discussion I have back in my home country where people say, well, I buy my clothes here and there, and if they do something illegal, then it should be forbidden, right? It's so simple, but it isn't that simple. And I think really awareness raising about the impacts of our daily and sort of innocent actions are really important in that regard. I just wanted to say, because I'm sure we're running out of time, this question about how do you deal with member states that haven't ratified, adhered to the different conventions and treaties. From the human rights perspective, you still have the UPR, you still have the special rapporteurs, which isn't conditioned by that sort of choice and deliberate action or non-action from a state. So in the UPR, you can bring forward, states bring forward recommendations to other states, and they are influenced by the information they receive. So civil societies that make their own submissions to that, they're gathered in with a sort of UN stamp on it in a compilation of submissions. The original submissions are all in their entirety available online. And what is being done in many countries is that civil society organizations gather up, they go to different embassies, they talk to countries that they think would be inclined to make, that sort of recommendations that they are looking for to a specific country and encourage that. Then again, we have special rapporteurs who go on country visits, dependent on the extension of an invitation, and I'll leave that to the rapporteur to speak more about that. But there are other ways around it in bringing these issues to the attention of the human rights system and to come up with very concrete recommendations for actions that states need to take. And they'll get a huge number of recommendations from the different mechanisms, but they'll be able to act on some of them. In terms of how to go about doing awareness raising with the judiciary, that's also one thing that our colleagues in the field is doing. They are working, giving trainings to lawyers, to judges, and so on and so forth. And then from our side, as a sort of office ambition, of course, the climate-related aspects of that could be strengthened if we had more resources to do that sort of work. But it's definitely part and parcel of our work in the field. To speak about defenders, and this is the toughest part, and this is really our reality check. And I think we're all, civic space and the protection of the people who we label as human rights defender, who may or may not identify like that themselves. It's really key to the mandate of our office. I think we're very grateful to organizations like Global Witness who put out these data and make them very visible. From my side, what we hear from states at the Human Rights Council and what we hear in the global discussions, when you talk about climate, environmental action issues and discussions, what you pick up on or not pick up on, really the issue of defenders is something that everyone can agree on. So it's a very clear-cut issues from us in that sense. Where there is no OHCHR presence, our colleagues on the ground really work to support defenders as much as they can. We have very different presences. In Brazil, we have a human rights advisor, whilst in Colombia, we have a huge country office with lots of different regional offices who can go and visit communities, indigenous communities, local communities, when threats occur, when violations occur. All of that is a risk assessment process that both individual defender communities and the UN system need to take, because you can also be retaliated against simply for cooperating with the UN system. So maybe it is not something that you want to, put forward. These are very, very complicated cases. We see a lot of examples. If you look at our press releases, often they come out of Geneva instead of from the country in which colleagues are working. Very often the rest of the UN system sends it our way because it's so difficult for them to do something with it, and it comes out with the OHCHR stamp on it. So there's a lot of, both silent diplomacy with states and very vocal diplomacy where nothing else has worked, where we try to highlight these cases. We are working to develop UN guidance for the whole UN system, specifically on defenders, and that's part of what we've been mandated to do by the Secretary General in his call to action for human rights, with that specific aim of trying to have the system more coherently work on these cases. But I think I need to stop here. Thank you. Thank you for these questions.
Yeah, I'll just pick up on that question on defenders, because that's one of the programs we work at UNEP. We work a lot on, also in cooperation with OHCHR, on environmental defenders and land defenders in particular. And to start with something negative, unfortunately, that Global Witness report that Therese just mentioned, and just to give you the numbers, and it's from my head, so it might be wrong by a few numbers, but 1,541 is how many environmental defenders were killed in the period between 2012 and 2020. There's a 7 years period, 1,541. And I think it's really important to mention the one, because it's every person's life, right? It's a life. And it's a lot of it in South America and Central America. That's the biggest impacted region, but it also happens in Europe. So don't underestimate how bad it can get anywhere else. But it's not so there. There are mechanisms, and that's what we're working on quite a bit. So one of I want to mention 4 things that can be done. So one is to bring this as much as possible, keeping people safe, to the attention of the existing international mechanisms, and there are several. We at UNEP have our internal mechanism on trying to intervene also at the sort of diplomacy level with the country if we become aware. The Human Rights Office has a special rapporteur on human rights defenders, which is a mechanism. Under the Aarhus Convention, which is a pan-European convention, there is a new rapid response mechanism specifically to address environmental defender situation. There is a rapporteur that was just appointed 3 weeks ago. It's for the first time. And then there is an Escazú agreement in Latin America. It's a very new one, but it has a special article to protect environmental defenders. So we expect that there will be something established soon as a practical mechanism. So use that. The other thing is there are 4 key stakeholders you need to work with to address the situation of defenders. One is enforcement agencies in the countries. They need to be aware, because they're very often they are part of the problem. So they need to be aware that this is something that is being watched, and what safeguards they need to follow and be able to demonstrate that they follow it. So enforcement agencies. Media, because very often media is used to blame defenders, to create them, to make them into sort of crazy environmentalists. So working with media. Judges, because one of the most effective ways to get defenders sidetracked is to dump a whole lot of what we call SLAP suits, strategic lawsuits against public participation. And that is going after activists and bringing cases, blaming them for damage to reputation of the company or anything, frivolous suits sometimes, but just to get them bogged down into litigation and costs. So judges being able to recognize a suit as a frivolous suit brought in by the company to silence somebody is very important. And the last really crucial thing, what we found for environmental defenders, is networking, bringing them together, and because there's a power in numbers and the mutual support, and that's crucial as well. So those are the 3 things I want to mention. And the last I want to mention is we're going to publish a climate litigation report. It's a new report. It will come out later this year. I just saw the first draft, working with the Sabin Center at the Columbia University. And that's really interesting numbers and very interesting graphics and statistics and examples of cases. So once it's out, I encourage you to look at this. And Eduardo, over to you.
I'll leave this here. Thank you so much. Well, we are very much over time, so I'm going to call Lloyd to have his words of thanks, or you think we can do that at the refreshments? Okay, so thank you so much to our panelists for joining us this evening and sharing with us very important insights and information, and also for those online. I'm not sure if Dr. Alfan is still online. Thank you so very much for your time. And we hope to collaborate with you again very soon.